You're watching the award-winning GHS-TV, a nationally recognized student television station.
Welcome to Let's Talk Business. My name is Kelly Bolton. Thank you so much for joining us today. I'm truly honored to have with us the esteemed Joe Duncan. He has been practicing law for many years, and the only things in life that are really certain are death and taxes. And as an attorney with Birch, Porter & Johnson, Joe assists clients with these inevitables by providing estate planning, administration, litigation, and mediation guidance. Please join me as we welcome Joe Duncan to our program. Joe, thanks for coming.
Glad to be here.
You probably could take up the entire season of shows with your experience. You've been practicing law a year or two, haven't you?
52.
52. Just a year or two, right?
52
well,
years, that's right.
Tell me about your experience in law and how things have changed or maybe not changed.
Well, I think they haven't changed in the areas that I believe that all of the lawyers, at least the ones with whom I come into contact, are very collegial. They're respectful both to the judges and to the lawyers, and for that I'm very, very grateful. I've practiced in Chicago and New Orleans, St. Louis, and you just don't see that kind of Southern charm, if you want to call it that, in all of those cities. But the main changes that I've seen lie in the form of mediation. When I started practicing law over a half a century ago, we had 8 circuit judges and 3 chancellors. And now, that many years later, we have 3 chancellors and 9 circuit judges. So wow. So between the 2 courts, we've only increased our judgeships by 1, and you can imagine our lawsuits have increased exponentially.
Right. So the court system is, it's got to be backed up.
It would have backed up, but for the foresight of Judge George Brown, who assembled 4 of us, I think around 1985, and introduced us to a pilot program called Mediation. And mediation was just a form of alternate dispute resolution. It was a way to avoid having to go to court and try the cases there. And after 2 days of mediation, 4 of us had 4 cases each that were ready for trial.
Right.
And we settled 15 out of 16 cases.
Really?
And that opened
amazing.
Really opened our eyes to let us know that the people that were ready to try cases, lawyers and clients, wanted to settle their cases and knew that trying cases really was a very expensive outing. And 2, that the mediation process was the way to do it.
That's interesting. Well, what do you think? Well, first of all, what is mediation versus litigation?
Well, now litigation is when 2 people hire the best lawyers they can hire, and they can't settle it themselves, and the lawyers can't settle it. And it could be one issue or it can be a myriad of issues. And then they'll take depositions and they'll interview witnesses, but basically then the court will give them a trial date and they'll go before court. It'll either be a jury trial or a non-jury trial in front of a judge. And then once they put on their cases, their trial, their proof, they lose all control over that case. They don't know what the jury's going to do, and they don't know what the person in the black robe is going to do. And then probably neither side will be happy with the outcome. And like as not, one or both sides will appeal the judgment or the verdict. And the appeal goes to our Court of Appeal that sits in Jackson, Tennessee, and that generally takes another year. And you think about another year of in limbo, another year of lawyer fees, and very few people fall in love with their lawyers. So you enter a mediation process, and a mediator doesn't represent any side, either side, and the parties come with their lawyers, and they're ready to try the case, but they get into separate rooms, and they try to convince the mediator of the good news and the bad news, the good points and the bad points about their case. And then after that's done, then the mediator will go to either side, and then the mediator will be kind of like a sounding board and go to the lawyers and the clients and say, you know, here's what's good about your case and here's what's bad about your case. And a lot of times that may be the first time that that particular client has heard anything bad about the case.
Bet, because they're obviously ready to litigate because they think they're right.
They think they're right because their lawyers told them that they think they're right.
Exactly. And so you're the unbiased third party in the room.
So I'm not there to win friends and influence people. Well, hopefully, I'm not there to win friends.
Exactly.
And I generally don't win friends.
Yeah.
But that's not my role. I'm there to settle the case. And you can't settle a case with somebody that thinks they're right all the time. If they think they're right, they say, well, I'm not going to settle a case. I'm going to win it. But most cases have warts. Most cases have problems. If none other than it's going to cost me a lot to try this case. I may win it, but it may cost me several $1,000s just to win the case. Mm-hmm. Well, I could give up some small bit. I could throw a bone to the other side and settle the case and get shed of it. Get shed of the expense, get shed of the heartache, and get shed of the exposure.
Well, it seems like we'd be a much better society if we could just, first of all, get along, but if we can't get along and we're going to fight about something, to do it through mediation, because anyone that I've ever known that's been involved in any type of litigation for any reason, whether it's divorce, corporate litigation, they've never been happy with the outcome, mm-hmm. ever. No mm-hmm. one's ever walked out and said, man, I won. Mm-hmm. It has never gone as quickly as they thought. Mm-hmm. And they're mad and their life is destroyed for those years in the process. And even when it's over, there's no sense of relief. That's been my experience.
What a good summary. that is really an accurate overlay of why litigation doesn't work. The only good thing about litigation is that it's final. Mm-hmm. It's the death knell to troubles. Right. It settles troubles. But generally in litigation, the parties walk out hating each other, and especially in a family context, if they're fighting over children or visitation or money, it's much better to resolve the matter in mediation and try to work things out where they can at least smile at each other for the sake of the children.
Yeah, that's a wonderful thing. I've got a zillion more questions. I'm glad you're going to be around for a little bit, but we're gonna pause and in a few minutes. I appreciate you being here. Now we're going to pause for a few moments for a short break. When we come back, we will resume our informative discussion about the mediation process.
Art is really an expression of the self. If you look at a piece of art, you can see the artist within it.
All just really depends on what I feel like doing at the time. I generally have different ideas every day.
I really get excited when my students come up to me with unique ideas that I've not heard of.
You can't let everybody tell you who you are or what your art is or how to be what you want to be.
I really let the students go according to how they're progressing, and I try to give them as much as they're able to handle.
Well, I like drawing a lot, and I like painting, and I like being able to improve my skill and show people my art.
I try to get them to think creatively. I think that's one of the few things that we as teachers really need to try to push with our students.
I can't sing. I can't act either, but I can do art. So that's why I chose art.
For more information about the Kappa program, visit ghskappa.com or call 755-7775. You're watching the award-winning GHS-TV, a nationally recognized student television station.
Welcome back to Let's Talk Business. If you're just tuning in, I'm Kelly Bolton, and today we have Joe Duncan, attorney with Birch, Porter & Johnson, as our guest. Today we've been discussing the mediation process. So, Joe, when we were paused for a commercial break, I was asking you about kind of the pitfalls, really, of litigation. And I'm coming from a layman. I've never been to court. I served as a witness one time. Yeah, I was called as a witness to a case, and just that experience was a little unsettling, to say the least. But I'll tell you my vision, and you tell me what's right or wrong. You know, if you have as a layman, if you have a trial and there's just a judge with no jury, I'm thinking to myself, this judge is going to make a decision about all of this, and he's only maybe briefed on the case with whatever's been turned in, and he's going to hear, and he might like my attorney better, or he presents it better, and might like me better, or might like the other person better, but he hasn't lived and breathed it, and we go in, and once he rules, it's over. And then if I've got a jury, if I'm litigating business, or I'm a divorce or whatever it might be, I've got a jury who may be from experiences in all different things and have no understanding of what I'm even talking about that I'm fighting about. And then they're going to make a decision. So that process scares me. I guess there's obviously some good to litigation, or we wouldn't have a court system. But what am I right about and what am I wrong about?
I think that last issue is probably the most important one. We have some wonderful judges in this area, but like all of us, they're not experienced in all areas, nor am I.
Right.
But we have some judges that are wonderful trying personal injury cases in front of a jury. We have some cases that are wonderful trying a divorce case and by themselves without juries. There are a lot of cases that are very specialized, such as the value of a corporation. As you know, we use the Blasingame rule in the state of Tennessee, and it has 3 aspects of the Blasingame rule, which are fairly complicated, and it's how to value the net value of a closely held corporation. And frankly, that's not something that I would like to put up to any of our judges. So if we do a mediation, we get to pick the mediator. And so a lot of times I will pick a mediator. I would suggest that both sides pick a mediator that's well versed in corporate matters, might not know anything about a divorce, or might not know anything about trying a personal injury case. So I think that's one benefit of the mediation process, is that you get to pick your mediator, whereas the judge, the judge is picked when you file your lawsuit, and that's just picked at random.
Interesting.
And
so they might not have a level of expertise, if you will, in that area. But if I'm going to mediate a corporate litigation, I could say Joe's the guy, and the other attorney agrees, and we both agree that you're the person that would mediate.
That's exactly right. And the other way, and this is not critical at all of our courts or our court system or our judges, but our judges are purposely quiet on that bench. Now, they may ask questions, but they purposely have to sit up there and listen to the case as it's presented to them and make their ruling based upon the facts as it's presented, as they are presented to the judge. Conversely, in a mediation, the mediator gets to ask questions and delve, well, have you thought about this? Have you thought about that?
So the judge does not, what is the parameters? Can a judge ask questions?
Well, we've had judges to do that. In fact, Greenfield Polk was a judge when I first started practicing law, and he would take over a case. And the guy I used to work for, Robert Dobbs, kind of jumped up and down, and Greenfield Polk said, Mr. Dobbs, you don't mind me asking questions, do you? And he says, Judge, I don't mind you asking, he said, I don't mind you trying my case. I just don't want you to lose it for me. And but basically judges don't get involved in the questions and answer. They say, well, that's the lawyer's job, and it is the lawyer's job. But a mediator gets more involved in the lawsuit. What are the facts? Have you thought about this? Have you thought about that? And brings out more underlying problems.
But does not rule on the case, correct?
Actually does not rule on the case correct. And that's another good point. A mediator's decision is not final. It is not binding. It is just a recommendation. A judge's decision is final. It's certainly appealable to the Court of Appeals. But a mediator's recommendation is just that. The parties may say, we don't like your recommendation, and then we try the case. But I'd say 90% of my mediations are settled because most people want somebody to tell them how to settle it. And frankly, the lawyers that appear before me kind of want to know, what should I do too?
Right.
Or help me tell my client what's best for the client.
Well, I would bet that a lot of times when an attorney goes into a mediation process with their client, it may be the first time they're really seeing what's happening on the other side.
That's right.
I mean, they may get it in the letters that go back and forth, say a bitter divorce or corporate, but they're not really hearing what facts are they have. And you come in the room, and I'm sure there's sometimes people that are very surprised.
You're right. In fact, studies from the American Bar Association have shown that even though their own lawyers may write them a full summary of the case, they only pick out what they want to read and what they want to hear. They only pick out the good parts. But when they hear someone else who doesn't have an axe to grind say, you know, you could lose this case. This witness that you say is so good, this witness is not admissible. That is hearsay. You won't be able to put that witness on the stand. Well, you know, that's pretty shocking.
Yes, exactly. Do you get, as a mediator, do you get to talk to witnesses at all yourself?
Rarely, but main witnesses I get to talk to are expert witnesses, such as on income tax issues or issues regarding valuation of assets in marital cases. As you know, marital property is to be equitably divided. Separate property is not. Sometimes in separate property is generally inherited property or property that the party had prior to the marriage or property that the party inherited during the marriage. And that's not to be divided. But the Never Never Land is maybe they had the separate property before the marriage, but then it increased in value during the marriage, and then you wonder whether the increase in value turned out to be marital property. So then I have expert witnesses on that. So.
Wow. Now we're going to take a short break. When we return, we will finish up this lively discussion.
This place, it's extremely unique.
You are pushed to do things that you didn't know you could do because someone else saw it in you.
If you're with us for your whole 4 years here at GHS, you get a great foundation of amazing classes.
Try the priest.
The approach we take to whether it's the fall play or the spring musical is that the students are truly the ones that are making the magic happen.
Tell all the people. You put the work in off and on stage. Not only are you on stage acting and playing a part, you're working, you're pricking your fingers, sewing the costumes, you're learning how to make exotic makeup designs, you're learning how to build the set that you're going to be planted on.
And as you grow with us within the program, your skills continue to develop and we build off your previous knowledge, and hopefully by the time you graduate, you're a well-rounded professional in a way, and you can move into any area that you'd like after high school and succeed.
For more information about the Kappa program, visit ghskappa.com or call 755-7775. You're watching the award-winning GHS-TV, a nationally recognized student television station.
Thank you for joining us on Let's Talk Business. If you're just tuning in, I'm Kelly Bolton, and we've been joined by Joe Duncan, attorney with Birch Porter & Johnson, as he shared his expertise in litigation with a focus on the mediation process. Joe, I think we're going to run out of time. I could just keep talking to you forever. I've got a zillion questions. I told you during the break, I would think it would be so exciting to be a mediator. First of all, my impression is that you get to go in a room with people that are obviously not getting along. Maybe they're not in the room together. And you get to see both sides come up with what you think is fair and equitable, present it, and try to bring two sides together that otherwise could have been spending, it could be hundreds of thousands of dollars, and drag their families, their friends, their businesses, their colleagues through, a pretty long and tumultuous process. So I know you have, before you did a lot of mediation, you did litigation, you've done divorce work, obviously you're an esteemed estate planning attorney and have been respected in so many areas, and I think that it's not common that you find someone with as diverse of a background that's been able to be as good in each of those backgrounds. And then when you take that and bring it into the mediation process, I think it's phenomenal. And, kind of looking back over time, are there cases that you, in the early parts of your career, you litigated that today you would say if mediation had been around, that would have been the solution?
Sure.
Yeah.
We just didn't have, at least in the South, we didn't have mediation. Mm-hmm. And it would have saved us a lot of wear and tear. I would probably have hair now. But would have saved the clients a lot of money. But you said something that really struck a correct nerve, and that is, it's interesting how the clients believe very strongly that their position is right. They've been told by their lawyer that their position is right, so that bolsters their confidence. And so they are shocked when they come into mediation and say, you mean what I've been told all this time is simply not correct. It's really hard for a lawyer to tell the client what a mediator tells. For a lawyer to say, you could lose this case. This witness that you've been relying upon, you just can't rely upon that witness anymore. You don't have any proof. Now, you may think you're right, but you're really not. You need to settle this case. And sometimes the client may say, well, I think I need another lawyer. I think I'm going to another lawyer that believes in my case a little more strongly.
They're going to keep looking until they find somebody that'll tell them that their case is good and strong. Yeah.
And believe me, they can find that lawyer, and they will have probably gone to the wrong lawyer. They need to go to a lawyer that'll tell them the truth, and that's the truth.
And when you're called in to mediate, or is there a list of mediators in the city and in the county? And then how is a mediator selected?
Really good question. Generally, the lawyers will select, they'll probably provide 2 or 3 names. One lawyer will provide 2 or 3 names and the other lawyer will pick them. Or they may provide one name and the other lawyer will say, that's fine with me. If they can't agree on a name, then the judge will say, well, John Doe will be the mediator. And then the lawyers don't have any control over who the mediator is. As a lawyer, I would rather have control over who the mediator is, because depending upon the matters or the issues in argument, I'd like to know who my mediator is. If it's a corporate matter, I'd like to get a corporate lawyer. If it's an estate matter, I'd like to get an estate lawyer. If it's a family law matter, I'd like to get a family law mediator. But the judges don't really understand that. They have a list of really good mediators, and they're going to pick the next person on that list.
That's interesting. And okay, so let's say you're mediating a case, and you've got the person that's convinced they're right, their attorney's convinced them they're right, and there is nothing you can say or do. And maybe the other side is willing to negotiate, maybe give some, even though they don't want to, but one side won't budge. So what happens then?
Well, our local judges want to know that. And
so a judge is still involved then?
Judge is still
Okay.
involved, and if that's rarely happens, but if it does happen, if the person just shows up and said, look, I'm here because the judge ordered me to be here, then the mediator's job is to draft a little statement that says both parties attended mediation on October the 25th, 2018, and the party and the plaintiff did not mediate in good faith. That's the death knell to the plaintiff's side.
And really?
And I've done it maybe 3 times. And of course, then they want to come back and say, "Oh, you misunderstood me." I said, "I didn't misunderstand you at all."
Yeah.
Because I told them on the front end. Now, if you don't mediate in good faith, if you don't make an offer, if you don't consider an offer, this is the letter I'm going to write. Go ahead and write it.
So, in what circumstances would a judge decide on that recommend or tell their court that we're going to take this to mediation? I mean, and does a judge have a right? I mean, if somebody wants to take it to trial, can they say no?
In most all family law matters, cases should be mediated. A lot of times you can mediate fewer than all of the matters in issue. Like in a domestic relations case, rarely, but sometimes it's who gets the divorce, who gets custody of the children. The visitation is always an issue. Will there be alimony? If there is alimony, how much and when does it terminate, if ever? And then how will the marital property be split up, and what the value of the marital property is? Well, those are 7 issues right there. If you could, if through mediation you could, if you could agree on 5 of them, then you only have 2 to litigate. Cheaper.
I wish you could stay on for the rest of the season. I may have to bring you back as a host. You could join me. We could question other people together, me and the mediator. We'd be awesome.
Thank you.
Well, we're going to once again thank Joe Duncan for being with us today. We hope you've enjoyed our discussion. We thank you for tuning in. To get more information on our show, please check us out on the web at GHS-TV.org, where we're streaming live 24 hours a day. You can also check us out on Facebook and Twitter. And please join me again next month on Let's Talk Business as we continue to explore the thriving Memphis business community. So now they can see us, they just can't hear us.